Welcome to the Atomic Level, the show where we decode the matters of wealth, one insightful conversation at a time with the rising stars in finance, business, and tech so that you can grow and protect your net worth and your net happiness. Today, we're back. It's Wednesday. This one's going live right now on Substack. It's also being listened to by you on replay if you're hearing this on our podcast channels. I'm Chris Snook, and I welcome back Matt Meuli for an AMA that we are going to be focused on a new category of advanced strategies. Matt, welcome to the show again.
Well, thank you, Chris. Yeah, it's nice to be here on this Matt chat and then to help out where I can, just to give, again, my opinions on some of these things that we talk about here as far as trusts and taxes and all of the good things that people worry about.
All right. So today, Matt, what we're going to do with today's Atomic AMA, we call it the Atomic AMA, the Ask Me Anything or Ask Matt Anything. Actually, it works well. It's nice to have M as your initial. We're going to go straight to one of the biggest blind spots in family wealth, right? And this is a big blind spot because what built that family's wealth in this specific use case are the simplicity and kind of the honest integrity of building a small business over time, right? Or a practice. That represents the majority of quote unquote millionaires in society. They are people who built it on the backs of a small business, a small enterprise, and something that doesn't end up in the Wall Street Journal, right? And they did it probably locally and in their jurisdiction, wherever they may live. And so they read about all these different things with billionaires, whatever. But when it comes to asset protection, estate planning, succession, it's usually the last thing that gets done for no other reason than they just don't have access to the information. So we're really going to unpack the audience questions that came on this series that we're posting on Shields and Succession around billionaire asset protection strategies for millionaire small business families. That's what we're talking about. Now, this is not offshore gimmicks. There's no hide the assets fantasy. This isn't another YouTube clickbait around buy, borrow, die. Not that that's not a cool strategy, right? This is not another binder on the shelf called your estate plan. What we're talking about is real architecture. This is architecture I deployed personally that I'm innovating with my own team, and Matt's a big piece of that. So I'm going to basically open kimono to your audience questions and to my own structures, and Matt's going to tell us the truth. We're going to focus right now on what these strategies are and how Wyoming specifically has some unique statutes and properties to it that I believe any state operator should be looking at. And so that's what we're going to go to today, very specifically. Now, Matt is an attorney. This is the disclaimer part. I'm going to start. You're going to finish, Matt. He is not your attorney yet, parentheses. He could be, but he's not. And so nothing that you hear today should be deemed advice, official legal advice. However, everything you pay attention to today should be considered by you to talk to someone who can help give you the proper legal advice based on your specific situation, your asset base, your business operations, and all those things. If you do want to speak with Matt or anyone, there are humans actually at his firm that answer the phone during business hours. We'll give you that number here shortly in case you want to have a follow-up of your own one-on-one, absolutely free of charge, to just unpack if there's an opportunity where he could be your attorney. So Matt, did I do the disclaimer right so we can just open kimono and just have a fun conversation?
I think you got pretty close there. The main thing is we need a signed engagement agreement to make me anybody's attorneys, and that's not only do they want me to be their attorney, I also have to accept the client. So there is a relationship there that needs to be documented and those kind of things. So got pretty close. So I'm just using my experience and what we've done with other folks and some of that, but maybe not my legal experience, just kind of the hard knocks that I had growing up, in business school, doing tax law, those kind of things. Just my experience. As you know, I did start being an attorney at 1988. As I tell everyone, I was only 11 at the time. My mom drove me to court and all those kind of things because I don't want to be that old. But that's not really true either, Chris. So, good disclaimer. Just remember that these are just kind of not legal advice, but more.
Well, and I'm laughing not because of the mom drove you to court at 11, because we know that's obviously not true. But the thing that I'm laughing about is that you do accept clients and you're very rigorous about it. But somehow I got through that matrix. And so for the rest of today's conversation, I'm going to talk very specifically about things I've learned building our own architecture here I'm going to open kimono to that. Matt's very key player in both myself, Atomic, and any of the interests so that they're compliant, so that they work within the and I'm going to open kimono to that. And we're going to get out your paper. This is your last warning of uh, Wyoming DAPTs, qualified spendthrift trust. We're going to talk when they make sense, why they would make sense, how to properly use. We're going to talk about how S corps, C corps, the situation. We're also going to talk about specifically belong in a structure like this and which ones AMAs we've done with Shields and Succession and Match Chats have investable assets of 500 because they just socked away and were good stewards for the last 20, 30. We call kind of wealth plan by design, but you don't necessarily consider yourself to be ultra rich, right? Maybe you're worth $2 to $10 million and you're super humble about it, but you've built that wealth with a majority of it coming from a business that may not be liquid outside of the cash flows that distribute you. And plan four, this is still, and even maybe more, still operating it. And before you're incapacitated, because any transfer of those has a timestamp on it that'll be important for future protection and things like that. So we're going to talk about all that, but we're also going to get into what a private trust company is. Owner can preserve those protections without destroying it over time, because setting it up is one thing. A lot of people might help you set it up. You can Google these kind of things and you'll find all kinds of people that'll set you up. That doesn't mean you're going to be protected. This is an active management strategy. And so we'll talk about the costs related to that. They're not substantial, but they are there. And so we'll talk about that too. And whatever else we get into. So ultimately protecting yourself before the storm. So there it is. Colorado residents, if 970-820-0090. Anybody else, especially around Wyoming asset protection, just call the Wyoming office. If you got assets onshore, this is where you call 307-46 obligation. You'll just get a pre-consult, see if there's something in here that that you wanted to go deeper on, and if there's a fit for potentially you guys working together. Other than that, so the first audience question, we're going to go around the horn here, but difference between, again, basic revocable living trust and using a Wyoming DAP or qualified spendthrift. We've talked about some of this in prior episodes, but just the short version of it: revocable living trust versus a Wyoming asset protection trust structure as it relates to long-term family assets. Just help people center themselves on why they would use one or the other and ground themselves in it if they're new to the conversation.
Okay, yeah. So, in our experience in most states, the a revocable trust is living one that, like its name says, it's adjustable, it's editable, amendable. You can actually revoke it, delete it, do all these things. You're basically in control of changing the rules of that trust if you want to. We call the person that's in control of that, we call them the grantor. They're the ones that, with an attorney or whatever, come up with the trust rules that the trustee and the beneficiaries need to follow. So that's what a revocable trust is. For the most part, that it's designed to avoid probate in your state. It's designed so that you go through contract law instead of statutory law. And it's just basically a way where you don't have to go through probate. Probate is that process where you're trying to figure out who owns the property after you die. It's kind of a big transfer of the property, make sure that all your creditors get paid, and that if you have anything left, that goes to your loved one. So it's a way to transfer the property without a trust and things like that. So a revocable trust, for the most part, is something that is used to avoid probate. Really do not have what we call asset protection with a revocable trust. And the reason is if you as the person can change all the terms of the trust, then your creditor asking you as a person to change the terms of the trust is allowed to do that as well. So when you look at the Wyoming DAPT, that stands for Domestic Asset Protection Trust. And in most states, the way that asset protection gets assigned to a trust is that you move from making a revocable, changeable, amendable trust into more of an irrevocable, non-changeable, non-amendable trust. So the rules, once it becomes irrevocable, are kind of set in stone. And now you need to get more permission, you need to get more actors in order to get money out of that trust or even to add money to that trust. And when I say money, I mean all assets, whatever property you're moving in and out. It becomes more of a fixed deal, more of an unchangeable deal. And that because of that, it gets some asset protection because if you as a beneficiary, the beneficiary is who the trust is written for, if you have to go through these channels to ask the trustee to receive property and the trustee can tell you no, then they can tell your creditors no as well. And that's where you start getting the asset protection. So the main difference is you go from a revocable trust to an irrevocable trust. Now, in a lot of states, the way that a revocable trust turns irrevocable is that you die. The grantor dies. Okay. And so that means that since the grantor's gone, the grantor can no longer amend that trust. And that's what makes it irrevocable. The states that have the spendthrift trust, the spendthrift just means that we're trying to control spending, so that not every creditor can get in there. But like Wyoming, those states that have that, you can start out with irrevocable, which is kind of advantage because you don't have to die to make it irrevocable. So that's the advantage there. There's only, a handful, less than 20 states that allow you to write these kind of trusts. They have a lot of different rules and everything in them. But generally, the idea is that you have someone in that structure in charge of saying yes or no to the distributions to the beneficiary. And that's what, if they can say no to you, they can say no to your creditors. And that's where you get the asset protection. So
Yeah, there's actually about 17 states that allow for that structure. Four are most common. The ones that are most known, I believe, are Hawaii, Nevada, Wyoming, and I think South Dakota. As far as like where the majority of this kind of activity has, we obviously are focused on Wyoming. I use Wyoming. I'm happy to nerd out with anybody on why, but there's a legacy there of property rights, charging. There's things in there, there's nuances in there that Matt can maybe get into if we get some questions around that later on this list. But at the end of the day, there are 17 places you could do it. There's four that are kind of commonly used. And the one that I'm focused on that we're talking about today and that this article piece was around in our strategy. And then the things that I'm unpacking with Matt is Wyoming because of a lot of rigor and research that went into that. So do your own research, but let's move on to the next question. So now we know kind of the difference, at least high level. We've level set everybody. I love what you said on an episode earlier. Maybe it was like one of the first weekly AMAs we did. You said, when people hear the word estate planning, they kind of see like this gargantuan thing with marble thing, and they go, "Well, that's not me." Right. And you said, look, estate plan, don't get the picture twisted. It's your stuff. And I say that because I think similar things happen when people think about generational asset protection architecture. That's a mouthful of words. It means something. It's important to understand. So we want to up level our vocabulary. But as a small business owner, they may not think about that way. Maybe they think about the word succession. Maybe. But these words are often, again, a little bit exotic to kind of the normal salt of the earth, just what I call the operator, right? And so that doesn't mean that's where you should stay in your mentality, but I don't want you to tune out when I ask this question, because the question that came in was, at what point does a family business owner move from I need an estate plan to I need a generational asset protection architecture? They may never actually ask the question to themselves that way. This person did, but they may not. What they probably are saying is, do I have the right plan in place as it relates to how this business down or retire from it or whatever, right? What do I need in place? That's maybe how the human would ask it in most cases. It's an architectural question, though, because most of these things, Matt, as we've seen, are closely held, and maybe they're even not even in a fancy entity. They might be in a partnership. They might be in a sole prop still. That's more common than people think. Maybe it's an S corp or an LLC, and those units are owned by whoever, dad, mom, whoever. So that's an architecture, right? Just like you said with probate. Like if you don't have a plan for your stuff, the state does. So this is similar. If you don't have an architecture for your wealth and you're making real money, you're making a couple $1 million a year in revenue or EBITDA in a small business, well, there is an architecture. It's just like not a great one. And so we just want to help you get a nice one. It's actually the best money you can spend. So at what point do they usually have this question? Is it when they're thinking about retirement and they realize no one's can run this business without them? Or when do you see it usually show up?
Yeah, that's a great question with a lot of moving pieces in there. Once someone has a business, you kind of look at the whole equation a little differently. The estate plan is the process of moving your stuff in an orderly fashion to the next generation. When you want, how much you want, to whom you want, and all those conditions to try to get that to happen. And in order to get that done, you got to have that plan in place before you pass away, because after you pass away, you can't make that happen. So that's the beginning. Is like I want my um, stuff to go to my family in an orderly way. I may or may not want it to have to go through a court process to do that. I may want to make it easier on them than harder on them. Just to give a good legacy for who I am as a person and how well I transferred my property to my family with the least amount of muss and fuss. So that's generally what you're thinking about when you're passing things. Well, then when you own a business as well, that kind of changes things, because now the business may or may not have value because of the way you run it. If you're a sole proprietor or whatever, if basically, if your retirement plan is to die at your desk, that's fine. But if your business is totally reliable on you, if you're the only one who can make decisions, if you don't have any uh, clients or customers are going to stay if you're gone, if you don't have anyone who knows the intellectual capital that you have to keep the business running, then that business does not have a value after your death. And that's a big thing. I mean, if you don't have a business that can be passed on, that a generational wealth evaporates when you die, maybe a normal estate plan is fine because you're passing zero in the business. But is that fair to your family? And is that even fair to yourself to work so hard all your life and have some kind of business that doesn't have value after you die? So once you get to that mindset where you're starting to say, okay, maybe I have some best practices that I can put into my business. I have some automation. I have some contracts I can write. I have some procedures I can put in there so that people would know how to run this without me. You can then start valuing business and have a value in the business that maybe it can be sold. Maybe you don't have to die for it to be sold. Maybe it can have value that you can pass it on to the kids, or you can have a third party come in and buy it. But you're now creating value in your business. And once you do that, that is another great time to start thinking about, okay, how is that value going to pass on to other folks? And the reason I approach it that way with a lot of the folks that I talk to is you got to have that plan in place before you may even know what is the benefits of asset protection. Well, asset protection is trying to keep other people from taking your stuff when it's not deserved. I mean, I don't really talk to a lot of people who say, "Yeah, I just want asset protection so I can do whatever I want. I can drive on the sidewalk and no one can take my money away." That's not what we're talking about. We're just talking about people coming after you just because they feel entitled to, or maybe they're envious and they just don't want you to have something that they don't have. But I mean, I think if you talk to a lot of people, we're willing to pay our bills up to a certain point, but, did we really cause, those $200 million damages in the automobile accident and those kind of things that some of those made for TV attorneys grab? I mean, was that really part of it, or is that just because someone knows how to get money? Those are the things we want to protect ourselves from. So when you start having a business and have value, that I think is when people need to start thinking, hey, What about asset protection? At least, do I need to get some kind of entity to put my business in so I can separate my personal assets from my business assets? So if the business does something wrong, let's let the person sue the business. Let's let the business pay for what it did wrong. If I do something personally wrong, well, let's let me and my assets pay for the wrong I did, but let's not commingle them so that if I did something wrong, you're going to take down my business and that kind of thing as well.
I
So,
think that's a very key point. I want to, I mean, I personally have experienced this in the worst way, right? I think it's a very key point because in theory, a lot of people think that, no, well, I have a business checking account. I have a personal thing. I don't commingle like some people do, but most people here, especially anyone who's been operating for a while is probably got that sorted out where in their mind, they go, my business is separate from my personal. But again, it's because they don't understand the architectural nuance, which is if it's a sole prop, if it's an S corp, if it's an LLC and it's a single member, or it's basically closely held by just family members, and the operating agreement's not much bigger than the boilerplate you got on LegalZoom when you formed it. It's mingled. And because when the right attorney that knows how to come after whatever the asset base is can pierce that, it's mingled. And the reason why I'm so passionate about this topic is personal, and because most of the small business owners, however they think of themselves, a couple million to $100 million in revenue, those are really small business owners, and yet they're substantially generating income, wealth. They provide jobs, they provide employment, and if they've been doing that for any length of time, 5, 10, 15, 20, 30 years, they'd probably do it the right way, or they wouldn't still be here. And so what I learned the hard way is when you wouldn't do something to confiscate someone else's wealth because you have the honor that built something like that, you don't see the attack. You can't predict it. You don't see it coming. So you don't have the architecture for it. You live in the neighborhood where you leave your screen doors wide open because the neighbors are nice. And there's a wonderful bliss in that. At the same time, it's probably really smart if you got something to lose to not have all your assets in that house. So if you want to leave the screen door open, fine. But just make sure there's like a weapons grade concrete vault somewhere not in that thing where all your stuff that you want to hand down for generations and keep free from a potential attack is. And that's what we're talking about here is that architecture and that insurance plan so you can sleep better at night. I want to ask this question. It's two questions. I'm going to blend them into one because we could talk about this for an hour itself, but we're going to do our best to be succinct and get through them. So, California business owner, everybody's favorite state to do business, next to New York. So family operated 42 years. All right. So they've been around for almost 4 decades. Throws off, ballpark here about 2.5 million in EBITDA. All right. So they've got 2.5 to 3 million a year in pre-tax income. And about 30 employees. And they're trying to understand what problems does a Wyoming architecture solve and what would it absolutely not solve? So that's part one. But I'm going to ask this other question that came in related to California specifically, because I think they kind of go together and we'll get a better, clearer answer. There's a lot of depends in here, guys. But so it says, should a family business itself move into Wyoming, even if that's possible? Or should the California operating business stay put? Much more likely because there's employees here, there's operating base, there's trucks, there's all that stuff, right? In California, but the Wyoming holding company gets formed and owns the equity and long-term assets of that. And if so, what does that design look like and what do you recommend? So those are the kind of the blended two questions. So let's assume it's a closely held family-owned business, no outside capital. And throws off about 3 million a year in pre-tax income. Forget what we could do to make that more advantage, right? That's the base. How would they use, and they got to keep operating here, meaning they have employees here, they have that. So the operating co is in California. It's not going to be able to move. How do they use a Wyoming holdco structure to protect, to preserve, to be strategic, to maybe even get some other benefits? Just high level. And then we'll go into some of the weeds. I have my own thoughts, but I want to hear yours.
uh, okay, yeah. So that's a pretty complex situation. Of course, the business is in California and subject to California rules. and the state statutes and everything. You basically, subject yourself to the rules of the state you're in by having a business there. But a lot of factors go into that. I mean, the business is basically owned by stocks or, an interest in an LLC or something like that. And that's a personal interest. That's something you hold personally. That's not something the business holds. So that's where a lot of people aren't thinking, outside the box, that if they do something personally and a made for TV attorney comes after you personally, because you personally hold the stock in your business, that's a personal asset. They can take that, regardless of whether you have that business in a LLC or a corporation or those kind of things. So, the first thing is just to find out, where do you want the ownership of the business to be. You don't want to be with your person. And those are kind of things where, yeah, you might want to put it in an asset protection trust. You might want to put it in another holding company or LLC. So that's some of the architecture that we're talking about, but you're not holding all your business interests in your own hands, so that you do something wrong, someone comes after you, gets a judgment against you. That's personal property. Even though it owns the business, it's not the business. The business can be set up correctly. So that's the first thing, is start thinking about, how can we separate that personal from business? And some of the personal that I think should be business is that ownership, the way you own that company. Uh,
Well, and again, to that point, depending on the state you're in, right? Because we have clients from all over the country. I just recently did a deep background check on myself, just for other reasons, like do it, understand what's out there, what's not, what's incomplete. And I was blown away because I've been an entrepreneur since 1999, basically, in one way, shape, or form. And so I can't even tell you how many entities I've formed over the years. And I started in California. So I was my career basically started in San Diego. I moved away from California for more than a decade in 2013. Left the state, wound everything up, and was in Colorado, was in Arizona, was in other places. When I did this background report, I could not believe every entity that I ever had, some of which I forgot. Like, it was one of those where I'm laughing. I'm like, oh my God, remember when I called it that? Like, every entity I ever had in the state of California, because of the way that they file things, my name was attached to, and it came back as if it was current. Like, stuff that was, one was bankrupted. One, like, I had to file bankruptcy in '08, like personal bankruptcy and whatever. And so, like, one of these things, like, I was like blown away. I'm like, oh my God, like, it looks like I own 14 companies in California. Like, and I'll sit on there, like, which ones, were no longer around, but it basically still had my name on it. And my point is that that state doesn't ever forget what you owned. And it's not hard to get. Like, that was the first layer that wasn't even done by the deep background check. That was just on, like, kind of a bank's run using Plaid. Many people have logged into their bank using Plaid. It literally came back as like, do you own these things? And I had to use the background report to show that they were dissolved. Right. And
mhm,
it was like, and I say that because, again, to your point, if something happens, your kid gets in an accident, or your wife or you, and something bad happens and someone comes after you, if you're in a state like California, they can see everything that you own.
correct. Yeah. And I, just to kind of use that as a gateway. I'll just take a diversion here. Back in 2008, when all the loans were going really bad, the real estate loans and everything like that, and they were repackaging them and selling them, on the market to kind of help everything happen, in that real estate collapse. I happened, for a client, I happened to buy one of those loans, on the secondary market that they were packaging and putting together. And I got this file that was sent to me from a bank. The bank that I bought the loan from had gone out of business. It was, incorporated by another bank. They were closing banks and having other banks take over. So I got this banking file, and I got a vanilla folder with the name on it for the loan and everything. And there were like 3 documents in there, maybe 4 actual slips of paper in there. But then there was this thumb drive that had 100 and almost 200 documents on it. And so I stuck that in the computer, started viewing those. And like you said, there were all the social security numbers of both the person who had the loan and the spouses and people in the family and things like that. And there had been trouble in this certain person's life where they hired a private investigator to check out some of the things that had been closed or had been stated that they were no longer in business and things like that. They had the bank or somebody had hired private investigator to make sure that all these allegations and statements were true, and everything with all the pictures was there as well. I had enough documentations on this person's life to become them if I wanted to. And that was all from a very, very small state-run bank that had made some bad loans and got, taken over by another bank. And, I got everything. And it just really surprised me to the point where, maybe privacy isn't such a bad thing if you can find it anywhere. And so, going back, tying this back into the architecture, sometimes just the privacy is getting into a different state with some of your assets, which is more anonymous and is more private than being in a state where, it requires you to put everything that you are and who you are on the Secretary of State and all these other uh, places where they have all your information. So that,
Yeah, I think again, for those, because there's so much stuff around there that, again, I think it's tantalizing, but it also distracts most people that we're trying to serve, which is that just honest broker, that small business owners build something of a practice or an area that throws off money, and they're comfortable. They're living a good life right now. No one's that we're talking about right now is struggling because they got, again, let's assume they've got $1 to $3 to $5 million worth of EBITDA a year right now, right? And they don't need to buy boats and cars and planes anymore, because they've either got enough or they've proven that to themselves. The reality is that they've got something real. It's not going public. They don't want it to go public. They could maybe sell it. Maybe it just transitions. Maybe they just wind it down. But at the end of the day, if you can't live on, $100,000 a month pre-tax income, then you need a budgeting workshop. So most people, no matter what they've got, already own a house. They already have this stuff if they're having this conversation. So what do you do with that money? Are you going to let it just get evaporated to the state, to taxes, to things like that? Or are you going to let it be like literally on someone's quick search and say, oh, by the way, here's the vault. It's got a door code. The code is 1234 Austin Bowers. And all you have to do is know where it is. And here it is. And you can go get it. Like, is that where you're going to store that excess? Or are you going to put that into a vault that doesn't have an obvious map to it and that isn't clear whether you own it or not? And if you do own it, has a layer of key protection where you're not the only one that could get into it, so that there's these layers of difficulty that make it harder for them to pick you as a target versus someone else. Or if they do pick you, that you kind of have something, preserved. And again, it's not about hiding from the law. It's about being prudent, right? So Wyoming as a structure, I'm gonna spit this at you to fast forward this. So what I would say to this person with all the depends caveats is, first of all, you have a California company. It's throwing off $3 million in EBITDA. Okay, great. So that means if it's an S corp, you're paying 1.5% of that in state tax before distribution, right? Because that's kind of how an S corp is structured. If it's an LLC, you're paying roughly $6,800 a year in minimum franchise tax board fees because you're somewhere between 1 million and 5 million in gross revenue. And so, depending on what your EBITDA is, you might be paying more than that. You might be paying almost 10 grand in minimum franchise tax fees to the state if you're structured as an LLC in California. So without knowing that, I don't know. So you're either an LLC and an operating company, or you're an S corp. You're one of those two things, or you're a sole proprietor, which is even worse. Now you're paying 15% on your Schedule C, right, on your EBITDA. If you're a C corp in California, then that's a little different, because if you're a C corp, then unless you distribute that and pay a dividend, right, you're not getting double taxed. You're just paying your 21% federal and then whatever your state tax is on a C corp. So you know what that is as the business owner. So I'm going to assume you know what you are: a C corp, an S corp, an LLC. Now, depending on that, all of those things have one thing: they either have shares or they have member units. And so my advice, but Matt's going to clean this up from a legal standpoint, is if you own those member units or those share certificates that you issued to yourself way back when you first started this thing, formally or not, then you own those shares and the voting control, in which case you own them in your name. And so you need to get those shares out of your name because they're a liquid. The K1 can still come to you if you need a K1 for certain reasons. But depending on how you're structured, you would look at what percentage, either all or majority or what, of those member units do I put into this investment holding company that is Wyoming jurisdiction? Because I could transfer from my name to the holdco. The holdco could essentially assume my shares. in which case now that ownership table is owned by a Wyoming hold corp that's probably taxed as a C corp as well, potentially. That's part one. So nothing's changed day to day. It's just who owns the shares of that day to day operation. Are you the person owning them, or is your Wyoming hold corp owning them? That's kind of step one. Correct?
Yeah, I mean, it doesn't matter. Well, what matters is that you have another entity that has some sort of asset protection holding the shares that were your, personally, uh, before. And like I was going before there, if someone sues you personally, that's now a business, whether it's another LLC or a corporation or whatever. And Chris, the reason why people have the LLCs and the corporations is for the limited liability. It's not for asset protection. It's just
Right.
against the business and everything like that. So that's what you're trying to do.
Right. So now so something bad happens, right? Chris does something stupid, not on purpose, but whatever. Gets in a car wreck, damages somebody's property, whatever it happens, right? Kid does something. So now somebody goes, what does Chris Snook own? And Chris Snook owns a job for this day-to-day company, and he might own a house, or he might own whatever he has in his name. He owns a used 5 Series BMW. So that's what Chris Snook owns. He doesn't own any shares in XYZ.
Right.
He no longer owns any shares. So he works there, looks like he started the company, but as far as we can tell, he doesn't own anything there.
Right.
Well, who owns it? Who owns it?
As long as the business isn't the one that harmed the creditor, they can take everything that Chris Snook has, but the business is still it's a separate entity, is separate from the action. And so that would survive, or may survive that creditor claim.
Right. And let's say that the claim is gargantuan, and I'm saying it just because this could happen. Let's say that, the settlement is huge, or the claim is big. Let's say I do have enough personal assets, because I don't know anybody's situation, but I'll just use myself as the example. Let's say I do have enough personal assets in my name still, where this is going to be expensive, and you know what? The only way to get this to go away is settle it by selling everything or filing Chapter 7. If I file Chapter 7, personal bankruptcy, I have to list everything that I own. Otherwise, there's perjury. So I list it all out, every asset that I own. I do not have to list assets that I do not own. I do not have to list things that I am the manager of, meaning I administer or I have some kind of role in, because those are just jobs. So again, depending on the structure of that LLC holdco, whether you tax as a C corp or not, it's another decision related to your tax structure. But as a membership ownership, right, I could be the manager of that holdco,
Right.
and not be a member of that holdco, which means I don't even own the holdco. So Chris Snook doesn't have to own the holdco. He could just be the manager, managing on behalf of the members of the holdco in Wyoming. Well, who's the member of the holdco? Who owns the holdco? And that's where you start to get into the structure of the architecture, where maybe that's the trust. Maybe that's a private trust company that owns 100% of the Wyoming holdco's share certificates and appoints Chris Snook, a human, the individual who lives in California, to be the manager of it.
Yeah, yeah, and that's the privacy architecture structure that can be had in those asset protection states, depending on their legislation and what they've written. Wyoming, we have that ability. It just needs to be structured, just as you said, pretty closely correct to that. Where perhaps it's the private family trust company as a trustee that holds or as the company holds the member of the holding company, it could be the trustee of the trust. I just think to kind of help the audience along is, if it's a business type of entity that you're moving, those typically can go into corporations and LLCs. But if it's private assets you're thinking about, that's when you think about trust and things like that to put the
Yeah. So let's talk about that piece, because that's a good segue to the next piece. All right. So if we think about I'm going to use my hands for those watching visually, and then, whatever. So if here's my operating company, whatever state I live in, this is my day to day, this is my bread and butter, this is my small business, and it throws off X million a year in EBITDA. And I do whatever I need to do to live comfortably and pay my taxes appropriately and take whatever write-offs I'm aware of that I can. And that's kind of that's my current state. Okay, so that's that. The problem with this is you are the owner of this. And so basically you've mingled personal liability with business liability in the event of something unfortunate happening that's outside of your control or in your control. And so forget passing it down generationally. There's all those other issues, right? Because to get it out, if I die, if I become incapacitated, how do I move control of this day to day when I'm no longer able to do it to whoever I want? My successor, my child, my wife, whoever, right? There's a whole slew of other issues that become really expensive after the fact if you have this architecture. But just as it relates to asset protection, what we're talking about is this architecture now takes its share table, its cap table, and it reallocates the ownership of that cap table out of my personal name and into my Wyoming holdco. So now I have a holdco up here, right? So I have a Wyoming LLC. I pick which tax designation it is. It's either a pass through, it's going to be a C corp, it's whatever I need for whatever the rest of my structure is. Again, not enough detail to get into that, but I have this now. So now my operating company doesn't change. I still work for my operating company, get my W-2 in California, do all those things. None changes there. But now the stock table is owned by this holdco. I am at minimum probably the manager of this, or maybe my attorney is. So I control the proxy, right? And now there's a cap table of this holdco. And if this is a business interest, then that cap table could be owned either directly by a private trust company in Wyoming or however I want to hold it. However, I have other personal assets over here because I've been making a couple $1 million a year as an individual in California or in whatever state. And I've bought things. I've bought real estate. Maybe I have some investment properties. Maybe I have some Bitcoin. Maybe I have some stocks. Well, they are not part of this operating business. So they may not be owned by this holdco. So what owns those? How do I get those protected? So that's where we're going now is what is a private trust company? What role can it play to not only hold my business interest in this new architecture called holdco and operating co, but my other personal assets that I don't need to live off tomorrow that I want to hand down for generations or not have issues with. So that's the question is what is a private trust company, number one? And then what makes it unique?
Okay, yeah. So the private trust company is basically, in the way that we look at them, is it's the trustee of the trust. So you usually have an asset protection trust and a private trust company. Instead of an individual being the trustee, you have the private trust company, the LLC, being the trustee, and it holds a lot of the kind of the responsibilities and duties of most trustees. But that trustee must be a Wyoming resident because that's one of the rules for having a Wyoming.
So yeah, I want to clarify that. Keep that thought. So essentially, the trust, the asset protection trust, you've called that a set of instructions. So think of that as like a layer or a documentation of a set of instructions around all these assets that are in that trust, how they are treated, how they can be transferred, how money can move in and out, who has the authority to do that. It's the trust layer is a set of documents that essentially provide very clear instructions. And then there's a trustee who administers those instructions. And that trustee is either going to be an individual or it could be an entity. Depending on the layer of asset protection and privacy you want, you may want to make it an entity.
Correct. And people do this all the time, Chris. I mean, even with their revocable trust, sometimes they get what we call a corporate fiduciary. That's just the bank or an entity that's being your trustee, after you can't be the trustee anymore. So very common thing. But yeah, that entity can also be a private trust company. You got to follow the rules of your state, for setting those up and everything. But the idea is for most of these trusts to work, you need to have the trustee in the state where the trust is. Okay. And that's where they break down. So
if I live in California and I have a Wyoming Asset Protection Trust, I cannot be the trustee because Chris Snook is not a Wyoming resident in that scenario, correct?
Yeah. And I think
I would have to have meaning I'd have to have my lawyer who lives in Wyoming and who's a licensed attorney be the trustee. Or I'd have to have a private trust company that I form with someone like you that is a domicile.
Right. You can have a trustee be a person or you can have a trustee be an entity. Do you want it to be your uncle or do you want it to be a bank? or those kind of things. So yeah, you get your choice of trustee. If it's a person and you have a Wyoming trust, it needs to be a Wyoming resident. As a person, if it's a business and it's a Wyoming trust, you need to have the business be in Wyoming. That could be a trustee at a Wyoming bank, or it could be in the private family trust company that we're talking about. And the reason some people opt for the private family trust company is it allows them to still be in control of most of the functions of the trustee, like picking the investments, deciding what goes into the trust. Sometimes a bank or whatnot won't be your trustee if you only have one asset in the trust, because they got a duty to diversify and be a good fiduciary and everything like that. So they're saying, hey, you can't put all your cryptocurrency in here and only cryptocurrency. You got to, we got to sell it and do other things, which is a problem for some people. So they want to be their own investment advisor. They want to make up their own composition of who's going to help them be the investment advisors. They may like their investment advisor from another state and don't want this Wyoming investment advisor to be in there. And they want to direct all the investment activities and control all the accounts and the assets. Okay. So they can do that. All we do in that case is we have what's called a distribution committee, someone who, from Wyoming, who says yay or nay to request for distributions. Remember, the asset protection comes when you have to ask for the money. One thing we didn't mention is the trust also identifies who's the beneficiaries, who gets the stuff. It gives the instructions to what the trustee has to do, but also tells the trustee who the beneficiary is, who they're running the trust for, who they're trying to benefit. So when a beneficiary asks for money, because they're the beneficial owner, they need to go through the trustee, and we just kind of separate those duties. So, the trust company, which is the client, can be the manager. They run everything except for that yay or nay on the distributions. So that's how that could be set up to make that happen. You also have to look at where is the property located, especially in like a state like California, because California says, if it's real estate in California, we're going to apply California rules. And guess what? California does not have a domestic asset protection trust statute, so it doesn't apply. And, a lot of those cases come out. It's typically even a California trustee, which, California trustee, California property, doing a South Dakota trust or something in California, they're probably not going to work. Okay. And it hasn't. There's been cases where it has not worked, recent cases, things like that. So you basically have to have them structured correctly. And you may even have to go
This is
relocate the property to Colorado, which I'll just tie that up with here when we're talking about what assets can go in there. Those can be your investments. Those can be, the private money that your corporation's paying you. You can reinvest that in a, investment company, or just personally in your in the trust.
So this could be like, a self-directed IRA, right? So in other words, I could set up a self-directed IRA. I could run that through a different LLC potentially, and then that LLC is outside of California, because I essentially then fund it like a private equity investment. I have someone else running that LLC in Colorado, in whatever state. And so technically now what I own is, I don't own the California real estate. Well, California real estate is going to be that there's just certain things you're not going to be able to do. Like if you're going to own something in a state like California, you got to pay California. Like if you're going to own something in New York, Madami's going to come take it. There's just no way you're going to get around those things. So you decide whether you want to keep owning that asset there, or if you want to reallocate that capital to a state where they will respect your property. That's a different decision. So one of the things though, where you do have optionality, and this is key, as a California resident, right? Where do you hold the property that is portable? Examples are promissory notes. Maybe you do hard money lending. Maybe you buy tax liens, right? Well, if you hold those in your personal name right now and you live in California, then those are California property. If those things that are basically paper assets with hard asset kind of contribution, right? Royalty payments, things like that, your IP, for instance, if you hold those in your Wyoming structure, and the paper and the notarized document that says, trust owns this property is in a box in Matt's office in Cheyenne, well, then technically that property owned by that Wyoming Asset Protection Trust and that architecture, for the benefit of whoever the beneficiaries are, is sitting in Cheyenne, Wyoming. It's actually physically there. If your cold storage wallet with multi-sig, right, for protection of your crypto or your Bitcoin is that Trezor wallet is in your basement in your California beach house, well, then they don't care who's got title to it in Wyoming. They go, where's the actual hard wallet? If the hard wallet is in a vault in an office in Cheyenne, then it's not only physically property in Wyoming, it's also titled to a Wyoming Asset Protection Trust. So there are things you can do where you take these assets that are stock certificates, maybe they're angel investments, maybe they're share certificates from the startups you founded and funded, those things that aren't physically like brick and mortar houses on the beach in California that cannot be moved, those things can be moved to Wyoming legitimately,
Mhm.
not just on paper, but in physical reality.
Yeah, and that's true, and I would just add that you may even wanna take a step further and have the records of income and, the QuickBooks, if you will, all that
Right.
record. You may wanna have those on a Wyoming computer as well, just saying, this is property, so, hey, state court for this stuff, it's in there, and now that we're up in that state that does have a domestic asset protection trust, we have to follow those rules, because
Yeah, and that's it. That's it. There's a lot of interesting nuances for those who like to nerd out on this, but it sounds complex. But again, it's when you start to really think about it, it's just about being legitimately buttoned up as it relates to your things. We have choices. You can buy your cloud data or your bare metal services for if you run servers, you can buy that from anybody. Have you thought about where that location is? Because you could use a company like Greenhouse Data, which has got server centers in Wyoming, all over Wyoming, because of all the benefits of the cold weather and right to keep those server farms running efficient. So if you have your bare metal that you're based or your virtual private server that you run all your company data through in a place that is actually physically headquartered there, well, then you're not just playing a game. That's truly where your cloud instant is. If you have a AI lockbox, like some of the things that we're doing with some of the higher net worth people, and that physical Mac Mini with all your open cloud and everything else, right, is on your desk. But then it's a node of one that has all the governance and all the financial stuff happening in whatever Texas, Wyoming, wherever you want to operate and have it be your main jurisdiction. Then essentially your operation, your headquarters, as it relates to those bookkeeping and data flows, is in a state that is more business friendly. And you can live where you want to live. You don't have to go suffer if you don't like cold weather just to, be protected. You can just structure yourself in a way where you and your butt and your family can spend the majority of the time where you enjoy, and your assets can live somewhere where they are most treasured, most protected, and most secure. It's just a rewiring of the way you think.
yeah, and just kind of the assets that you wanna protect and not necessarily all the assets that you have. I mean, that's one of the fallacies. If you put everything that you have into, asset protection trust, and then the court asks you, "Did you do this just to avoid creditors?" It's like, "No, no, I honestly can live on nothing, Your Honor. That's why I."
Right. Yeah.
It goes bad. A lot of these cases hinge on the believability of the witness. So, we're talking about having things in Wyoming and having uh, actual physical presence and things like that. You're just a credible witness. You're just telling the truth, and that's what
Right.
can swing you. But when it comes to asset protection, no matter how much my client has, I usually ask it to them in the following, it's just how much money, if you could put aside in a vault where your divorces and your creditors and potentially, bankruptcy and those kind of things could not take that away. In other words, they could ruin you on everything else you have, but you could start your life over with what you put in that vault. How much is enough? Would it be nice just to have 250,000 in there? You could start your life over, 300,000, 500,000. But a lot of times I leave it up to the individual to let them tell me what they think is enough. And the reason we can do that is, if you did have 500,000 investments, we can you can set that aside because that's not what you need to live on and things like that. You're not just doing it just so you can never have to pay a bill again. I mean, you're just doing it so you have something to take care of your loved ones. Should something bad happen.
Right. Makes me think of another thing. So here's another use case. This is me vamping because I've had questions about this separately. It didn't come in from this week, but a lot of people now have children who have been athletes, right? High school, college athletes. And unlike the era where most Gen Xers like me grew up, where if you didn't make it to the pros, you were lucky enough if you got some kind of scholarship for college at D2, D3, or well, not D3, but D2, D1, AA, D1. And that paid for whatever your education was or wasn't, right? But you weren't allowed to take as much as $300 in a gift without getting banned for life, right? Now that world's changed in the last several years with name, image, and likeness, right? NIL deals, the portal. And so why am I bringing this up? Because you might be a family who just had enough disposable income to be in the top 5% of the planet, right? And so maybe you're a three to four to $500,000 a year family, and you have a nice life, and that used to be a lot of money. Now that's kind of like, depending on which state you live, upper middle class, if there is still one, right? But you put your kids through private school, or you put your son and daughter or whoever into sports, and you were paying $5,000 a month for travel team, and they're a softball kid, or they're a volleyball kid, or they're a basketball kid. Well, all of a sudden now those children, because of Instagram, because of NIL, because of recent changes, can be making, 50, 100, 200,000 or more a year off their NIL. And this is happening at the Division II level, at the Division I AA level. Agents are now coming down to ninth grade. I have a buddy whose son is in ninth grade and who's already getting offers because the agent has to go downstream to find the kid before he's a star. Because now in college, like Shedeur Sanders was making $20 million as a Colorado Buffalo. Why would he go to the pros early when he can make $20 million playing in college? Right? The extreme examples are there. Now, why am I saying all that? Because everyone remembers when the symbol formerly known as Prince became a thing. What most people didn't know, because I didn't even know this, the reason why that happened wasn't because of his ego. He lost the rights to use his own name. So he had to change it to a symbol because he could no longer be Prince. Jessica Simpson had a $50 million a year business selling clothing in like Target or something years ago. She had to literally be bankrupt and go back and buy her own name, Jessica Simpson, back from the creditors after that. She couldn't use her own name in commerce because it was part of the deal. Why I'm saying all that is because whether you think you're IP or not, you might have a child who is. And so where does that IP live? Where does that NIL, that name, image, and likeness right live in a world where social media, influence, creator economies, Substack, and everything in between are the biggest moneymakers, where trust is the only thing you can't automate. And humans will look at other humans. Those kind of things that are what are basically a liquid assets in most people's mind need to be protected as part of your family strategy too, even if you're just a small, humble family business, because you might have a star in college who makes $500,000, $600,000 a year because they have a following on Instagram watching them play volleyball. And that name is valuable to protect from dark deep fakes and from a lot of other things, but it's also a monetary equivalent. And that right could be owned by a Wyoming asset protection structure that then has a distribution company with a revocable right to be the exclusive distributor for commercial purposes of that IP. So now the IP is held by your asset protection trust in a vault in Wyoming, right, through whatever structure, whatever it talks about. But you could have a California LLC or a New York LLC or a Delaware, whatever, that says, hey, guess what? I have the exclusive rights to market Chris J. Snook.
Yeah, and you're licensing those from the
You're licensing those from your asset protection architecture so that if someone comes and says, I hate Chris J. Snook, I don't like him, I want to bury him, and they do that, they can basically come and sue the company that has the exclusive rights. And I can basically have my trustee revoke the rights for that license going forward from that company. And I can say, here you go. You now own that entity. Congratulations. You own that entity and good luck, because it no longer has the rights to distribute the thing that you were mad at. Those kind of structures are smart for families, for anyone who has something of a name that they want to protect in a world where our names are now becoming monetary events.
right.
Our writing, our voiceover, all this stuff, right? We've all seen the deep fake calls of, grandma getting called from the grandson and need 25 grand. And it sounds just like grandson. because the grandson was on streams or TikTok and somebody used 11 labs for $8 and knocked it off and now just robbed grandma of 25 grand. There's those kind of attacks you want to prevent. But then there's just the fact that like you have an asset. It's called your name and your likeness and if you're using that at all in commerce, then you should not hold that in your direct name. And you should not assume that it's protected because it isn't.
Right. Yeah. I wholeheartedly agree. I think that's one of the things, that we can maybe explore further on further episodes and things like that. The other one I'd throw out there is a lot of us are dabbling on Amazon. We're salespeople on Amazon. Do you have your limited liability company for that, or are you using that name as a vendor and the same thing that you wouldn't mind someone taking from you and becoming you as this preferred salesperson on Amazon? So there's a lot of applications when you look at the separating business from personal, and like you say, your name, if it's being monetized, that's a business. That could be put in an entity, just like you suggest. So
Yeah, and I want to wrap up this. I want to wrap up this session with this. This is going to be the commercial part of this, but I think it's earned. So thanks, Matt, for the questions. Obviously, if you guys have more, or if you have situations that you want to discuss privately and one-on-one with Matt or with one of the team and personally, then you can call Human Actually Answers. We don't have one of those weird phone tree things over there. 307-463-3600 is the number for all 50 states. 307-463-3600. Feel free to give the team a call over there, and they can understand your situation a little bit more closely and put you in the right direction and see if there's a fit. As far as the cost of maintenance of this, I think that's worth speaking at. Like, if you're making the kind of money that we just talked about for the last hour, you've spent 15, 20, 25 grand on stuff that you don't remember to get a tax write-off, to get something in place, to do whatever. It's not nothing. It's also not a lot of money when you think about what it could save you in pain later. And you're not looking at that on even an annualized basis for most people. For most people on an annualized basis, once you're properly set up with whatever architecture you need, you might be looking at $500 a month to have a very buttoned up maintenance on this with someone in the role of a trustee. Now, you might spend a little bit more, you might spend a little bit less. But again, when you think about it that way, you go, well, that's not a lot of money. So all this complexity, these billion-dollar strategies that everyone who does have billions of dollars uses at scale and that needs a family office to run are available to you now because of things like this, platforms like this, conversations like this. And you're talking about maybe a $20,000 kind of setup and $500 a month. So you could do the math on that. How much do you want to protect? How much do you want to preserve? How much are you going to be worth 2 to 3 to 4 to 5 years from now? And do you want that in place as you scale that so that you can kind of build with that certainty? I think you do. I did. So I did it. All right. That's part of the commercial part. The second part of the commercial is credible witness. You brought that up. Being a credible witness is key. Meaning like that your story makes sense. And it's not like one of these things where you look like a guy that's just dodgy and whatever, because you've legitimately done things by the book. So if you live in California or if you live in a state where there's state income tax, there's all these rules, there's no way around that. You can't say that you own a company over here, wherever over here is, and that you work there when you live, more than 183 days in a place. So how do you pay yourself? How do you do it right? How do you keep it all above board? One of the brand partners that I'm excited to announce that I've been working with forever is called Pebble, Pebl. Personally use them. They're what's called an employer of record. They used to be known as Velocity Global, and they kind of invented the space of employer of record. One of the strategies for employer of record is you can basically hire people in up to 185 countries. And you don't have to worry about setting up nexus or jurisdictions or filing like you would if you were doing a PEO or some other direct hiring strategy. So in the world of remote work where talent is wherever talent wants to be, it's just good to have an EOR in your structure, in your architecture, so that you can hire the best and not have to worry about whether you got to file 15 different states or whatever, right, to pay taxes now. It's just a nightmare. Just have one throat to choke that's fully compliant, that does this for a living in 185 countries, and you get one invoice, your payroll comes out, and it goes to them in whatever local currency or whatever jurisdiction they are in 185 countries or in all 50 states. So I encourage you to check out Pebble. I use them personally. As it relates to this strategy, what you can also do is you can pay yourself without being the owner operator of the company. When it comes to lending, that's great because they say, do you own this business? You say, no, I don't, because you don't. You work for it and you have a W-2 from a company that isn't a company you own. In this case, it would be Pebble. So if you're interested in some of those things, normally it's like $3.99 a month per employee that you hire, kind of as the maintenance plus whatever the payroll and taxes and benefits that you choose are. So $3.99 a month is kind of their normal thing. For the podcast listeners, for the friends of this channel, they're doing a discount on that right now. It's at 25%. It changes, terms and conditions apply. Check them out at hipebl.ai. HIPEBL.ai. Check them out. I use them. I encourage you to check them out if you want to understand how an employer of record situation could help you with your architecture, be compliant in your state without having to make your nexus in states you don't want it. So anyway, that's the plug. Matt, I'll leave you with the final word and we'll wrap it up for this week.
All right. Thanks, Chris. Yeah, I appreciate that. Just so everyone knows, I have not yet worked with Pebble. So, that's your recommendation and we're,
That is my recommendation.
so,
Matt is being indoctrinated as we speak. He's doing all the digging for me. But
looking
yes,
forward to checking them out and doing all those things. Cause it does sound like a viable strategy. I'm just saying that although I'm on the call right now, I'm not the one endorsing that. So wanted to
that's
get that out there, my compliance rules, all those good things.
yes.
But
We
hey,
do everything by the book here, right, Matt? So that is very important to understand is we're
right.
happy to have an ecosystem, just like we're happy to have Matt Meuli in the ecosystem, but they are not the same thing and they are not related at this time. So very
I
good.
guess my final words would be, hey, do whatever you can to protect your assets.
That's right. CYA. There you go. All right, buddy. We'll see you next week. Thanks. Thanks, everybody.